Hello and welcome. Today we are talking about medical negligence in Nigeria, what it really means, how to know if you have a case, and the legal steps available if medical care goes wrong. This explainer is designed for patients, families, and anyone seeking to understand their rights in the Nigerian healthcare system. Let's begin. Medical professionals in Nigeria are legally accountable for their actions. When carelessness or substandard treatment causes harm, the law provides a pathway for patients and families to seek justice. This guide will help you understand that pathway. First, it is important to understand the difference between a bad medical outcome and medical negligence. Not every unsuccessful treatment is negligence. Sometimes, a doctor follows all accepted medical procedures, but the treatment still fails. In such cases, the law does not demand perfection. If the doctor met the reasonable standard of care, then negligence has not occurred. Negligence arises when a medical professional falls below that standard. For example, when a doctor skips a required test, ignores clear symptoms, prescribes the wrong medication, or acts carelessly, and that failure causes harm, the law may consider it actionable negligence. So how do you know if you actually have a legal case? In Nigeria, medical negligence claims are assessed using a three-step test. All three elements must be present. First, duty of care. Once a doctor or healthcare provider accepts you as a patient, a legal duty of care automatically exists. Second, breach of duty. You must show that the healthcare provider acted carelessly or unskillfully, meaning they failed to meet the standard expected of a reasonable medical professional. Third, harm caused. You must prove that you suffered actual injury, loss, or damage directly because of that breach. A key point to remember is this: it is not enough to show that a mistake happened. You must show that the mistake caused the injury. So what does medical negligence look like in real life? Common examples include misdiagnosis, where the wrong illness is identified or a clear condition is missed, medication errors, such as prescribing or dispensing the wrong drug or dosage, surgical mistakes, including operating on the wrong body part or leaving surgical tools inside a patient, and lack of informed consent, where a risky procedure is performed without properly explaining the risks or obtaining the patient's permission. Negligence can also include general carelessness, such as failing to sterilize equipment or ignoring a patient in urgent need. Who can bring a medical negligence claim? The injured patient can sue directly. If the patient is a child, a parent or legal guardian can sue on their behalf. If the patient has died as a result of negligence, the law allows a spouse, parent, or child to sue as the next of kin. This ensures that families of deceased victims are not left without legal recourse. Next, who is legally responsible? Medical negligence cases are not limited to doctors alone. Hospitals are often responsible under what is called vicarious liability, meaning they can be held liable for the negligent actions of their staff. You can also sue the individual doctor, nurse, or healthcare professional who caused the harm. In some cases, the hospital itself may be directly liable, for example, where it failed to provide a safe environment, adequate equipment, or qualified personnel. In practice, compensation is usually paid by malpractice insurance, not directly from a doctor's personal funds. Now let's talk about time limits. Time is critical. In most cases, you have 3 years from the date of the incident to file a medical negligence claim. However, if the case involves a government-owned hospital, the timeline can be much shorter. Under the Public Officers Protection Act, you may have as little as 3 months to file your claim. If you miss these deadlines, your case may be dismissed, regardless of how strong the evidence is. Do not wait. If you believe negligence occurred, the first practical step is to secure your evidence. This includes medical records, test results, prescriptions, and case files. Financial proof, such as bills and receipts, is also important. An independent medical opinion may be required to confirm that the treatment fell below acceptable standards. In cases involving death, an autopsy report can be critical. Be aware that hospitals may delay or withhold records. A lawyer can assist in legally compelling their release. The second step is to consult a qualified lawyer. Medical negligence cases are complex. You need a lawyer experienced in medical or personal injury law. Your lawyer will review the facts, help obtain difficult evidence, and calculate the fair value of your claim. Often, the first formal step your lawyer takes is sending a demand letter to the hospital or provider, outlining the grievance and requesting compensation before filing a lawsuit. If the matter proceeds further, the third step is filing the lawsuit. This involves filing legal documents in the state high court. The court will notify the doctor or hospital, allowing them to respond. Even after filing, many cases are settled out of court to avoid a full trial. You may also file a complaint with the Medical and Dental Council of Nigeria for disciplinary action, such as license suspension. This process is separate from suing for compensation. Inside the courtroom, the burden of proof is based on the balance of probabilities. This means you must show that it is more likely than not that negligence occurred. Expert testimony is usually required. Doctors will testify about what a reasonable medical professional should have done in the same situation. Both sides will present expert opinions, and the court will weigh the evidence. If successful, what compensation can you receive? There are 2 main categories. Economic losses include medical expenses, rehabilitation costs, lost income, and loss of future earning capacity. In cases of wrongful death, dependency costs may also be awarded. Non-economic losses cover pain and suffering, emotional distress, and loss of enjoyment of life. It is important to be realistic about the challenges. Medical negligence cases in Nigeria can be slow. Doctors may be reluctant to testify against colleagues, legal fees and expert costs can be high, hospitals may attempt intimidation or pressure families into silence or small settlements. These obstacles are real, but they can be overcome. Act quickly, document everything, work with specialists who understand medical negligence, and persevere. Nigerian courts have awarded compensation in malpractice cases, and the law recognizes your right to seek justice. Pursuing a claim does more than provide financial relief. It also forces healthcare institutions to improve standards, protecting future patients from the same harm. If you suspect medical negligence, consult a lawyer. Silence protects no one. Before you go, remember this. Knowing your rights is only powerful if you use them and if you share them with others. If this explainer helped you understand medical negligence in Nigeria, please subscribe to the Lawpadi channel so you don't miss future legal explainers that break the law down in simple, practical terms. And please, share this video with your family, your friends, and anyone who may need it. You never know whose question this answers or whose situation this helps clarify. At Lawpadi, we've been helping Nigerians understand the law for a decade, and we are just getting started. Thank you for watching. Stay informed, stay empowered.